Chair, if I may add.
Yes, Honorable Member, you are welcome.
Chairperson and Honorable Sangun, I'm pleading with you, honorable members, to listen to the theme message of Honorable Matis. Is that the first list has been exhausted through consultations. If there is additional list, let's get those people, let's provide. Now, in answering Honorable Sangun's concern that these people have got there's no evidence before us or anything of that sort. That is the purpose of the consultation process, to establish if we'll get anything or not. But if it's very clear, open to us as a committee that we're not getting anything here, let's agree even without subjecting such names to consultations. But the legal team, the evidence leaders are here to help us to say, okay, we received these names, we've consulted with these people, and we think the following can help the commission arrive at a reasonable conclusion. But for us to just come and say the list is too long, this problem is not too long, it's humongous, it's a huge problem. To be compared to the list we have. We can't even complain about the list. The road is so deep that the list is expected to be beyond what we've presented if you come to appreciate the road we're dealing with. So we cannot start on a point of laziness and say, no, this is too long, this is going to take too long. Some of the people are not going to be, we can take 4 a day. We are allowed to ask questions for 30 minutes. Some of us will not even have questions for other witnesses. They may be so clear. So let's not assume that, therefore, if it's 64 names, it will mean 64 days or 100 days. No. Let the evidence leaders help us through consultations. The names are huge, including on the matter of sub judice. Only the evidence leaders will say, we have consulted with these people and we realize there's going to be a serious problem of people self-incriminating or this or that. And therefore, we think the following people cannot appear until these matters are exhausted before the judiciary. So to now get list of people that were mentioned, people that we also think they've got a role to play in rescuing the judicial system in South Africa, the justice system in South Africa, we say no, let's leave these names, they are too long, we'll see as we go along. Why do you have an ad hoc committee without people coming to appear before it? So please, Chair, we plead that let these names that have been submitted be subjected to consultations, and then we shall be advised, including the president. The president was mentioned in the committee where the minister said he consulted the president on the disbandment of the PTT. Why is Parliament being used to shield the president from accountability? We are now failing again in our responsibility to hold the executive accountable. You are so ready to hold ministers accountable. But when it comes to the president, no, let's see if that the need has arisen from the committee in Parliament, from the committee, but equally from accountability point of view, because the president has got a duty to account to us as to what whether he knew if his minister was involved. You want to shield it, because I know central to what you are suggesting is that the president must not appear before us. There's no need for that, and you are just ashamed to go straight about it. It's wrong. The president is not above the constitution. The president must be held accountable by Parliament, and this committee should do that. And we appeal that no one must be treated differently. All of us must be subjected to the accountability, and the executive, more in particular, must be held accountable by Parliament. That's why they established the ad hoc committee. Thanks, Chair. Thank you, Chairperson. I listened carefully to the Chief Whip of the ANC, and in trying to philosophize his input, he runs away from pointing at the rule or the terms of reference that deals with recusal. If you have not dealt with recusal in the terms of reference, and there is no specific rule that is being referred to of Parliament that deals with recusal, we are not in any position to use our majority or our feelings when it comes to recusal. That decision lies with the member consent, like you summarized in the previous meeting, that if you were mentioned, you were not going to proceed to chair us. But there's no rule. Which law are you referring to in dealing with dispute? Because there must be a rule that deals with conflict and says this is where the conflict is. And on the basis of that, we are of a view that the member must recuse herself. I said to you, you are not in any position to remove or expel any member from this committee. You are not. These people were properly sent to come and sit in this committee by Parliament of the Republic of South Africa. And you don't choose who sits in this committee, who doesn't sit in this committee. This has been resolved by Parliament. You cannot constitute yourself. You are constituted by Parliament. And therefore, it is incorrect. I don't care who you're referring to. I don't care which political party they refer to. I stand for justice. And justice will require us that we raise the concerns we've raised and leave it in the hands of the member concerned. You will share this experience, Chair, together with Advocate Bredenbach, that in the JSC, we tell members that if there is a conflicting interest in relation to a judge that is about to appear before us, you have to take that decision to recuse yourself. Or if you don't want to recuse yourself and you seek the collective wisdom of the members of the JSC, you will then say, I know Advocate Bredenbach, and this is how I know her. And we've been together this way, that way. Members are like, no, let's proceed. There's no problem. We believe and to these matters of the interviews. But otherwise, if you feel personally of interest. So please, Chair, there's no South African that says we must deal with members in an unfairly manner in an attempt to save the failures of the previous regime that has gone below 40%. It's not our responsibility to cleanse you up. It was your mess. You messed it up. And you're not going to do it now with us. That you isolate the people that you think are not going to serve whatever interest you might be representing. So from where I'm sitting, there is no any conflict. The name is on the list. Let the name, like all the names, be referred to our legal team. Let the consultation be made. Perhaps in that consultation, the legal team might even say to our member, but look, don't you think maybe this or that way? And then the next thing we hear from a member saying, no, you know what? Upon reflection and consultations, I now accept that I must step aside. And then you proceed with this thing. I'll come if I'm invited to do so. But this thing of passing a motion of no confidence against the evidence leaders that we have appointed. And before we appointed them, we even said, evident leaders will not tell us anything. They will not control us. They will come and give us a legal opinion. We will decide on our own if we take that legal opinion or not. So they are here now. Let the names be referred to the legal team. Let it make consultations. Let it come back to us as we proceed and say, yes, we can hear maybe the following day, let's not have this witness. Let's have a committee meeting to make reflection on further witnesses and all of that. Then they will say to us, the following names are helpful, the following names are not helpful. And we are of a view that the honorable member also, by this kind of legal, general rules or practices, we think the member should recuse herself. And it is for her to make that call. So please, let's have confidence in you can't say we've got this list, provisional, and as we go along, consultations will be made and all of that, and then a certain person must be removed. We said, let that responsibility lie with the evidence leaders who will advise us on whether this person is going to help us or not. And if Honorable Barnard, who's mentioned, is not going to be helpful because she's conflicted or anything of that sort, they will point to that and make a proper legal argument as to why they are saying what they are saying. Not this thing that we're doing now, because we want to constitute ourselves. We can't constitute ourselves. And we have no right to expel any member from this committee. If anything, let Parliament revisit whatever resolution is taken on in terms of who constitute this committee. Thanks. I'm not talking for any member. I'm talking for all of you. It's nice now that you say the things you are saying. Wait until the tables turn and you are told you are conflicted and you can't even see that conflict. Your conscience is very clear that you are not part of this and you have never been involved in any illegality. So let principle be principle. It doesn't matter which political party a person belongs to. It doesn't matter the race of a person. It doesn't matter the gender of a person. Justice must always be justice. And if we stand for justice, we will know how to deal with conflict of interest. Thanks, Chair.